No, I don't believe so, Your Honor.
Okay, let's get started.
Yes, Your Honor.
This is cause number DC 182748, Kimmel versus SND operating. You may proceed.
Thank you, Judge. Like I said, Micah Satterwhite here for the plaintiff, and it's my understanding that the parties have come to an agreement on an amended scheduling order. And because of that agreement, we ask that the court enter it.
Okay, this case is quite old. Let me see, when are y'all set for trial? Y'all are currently set on September 28th.
Yes, sir. And looking at this proposed order that the parties have filed, it looks like they're just requesting a short continuance to February of 2022.
I guess the case was filed in 2018, so beginning of 2018, so 2019, 20. This is over 2.5 years old. Why is it not going to be ready by September?
It's my understanding, Your Honor, that there's several motions that are still pending before the court that need to be ruled on that could change the landscape of this case, but I would defer to the other counsel defendants to talk about those. Like I said, there should be pending later on at the end of this month, but for release purposes of my understanding is that the parties should come to an agreement on this, but I can't speak for the specifics of the case, Your Honor. I apologize.
Okay.
Your Honor, if I may, this is Brett Smith on behalf of Ray Systems. Yes, the case was filed, I believe, in 2018. My client, Ray Systems, wasn't sued until the latter part of 2019. Okay. And we've been playing catch up since, taking some fact witnesses, depositions, et cetera. And then plaintiff resolved claims against a co-defendant, S&D and Vortis, and Griffin, who's still in the case and a co-defendant, has been trying to get depositions of some of their representatives. And that has been very challenging because this case is not only about what caused a gas leak, but also what failed regarding notifying authorities that there was a leak. And S&D and Vortis were the well owners, operators, and information from them is critical to further address the issues of the case as far as causation. And Griffin has been trying to obtain information from representatives along with an individual who's a defendant, Billy Nip. And I think there's a pending motion for contempt for Mr. Nip failing to appear for depositions. So there's certainly outstanding fact discovery that has occurred. And then we have expert depositions that need to be taken to adequately prepare this case for trial. And those have yet to be done. And it's August, 2nd. So we're not going to be in a position to be prepared to try this case in September. So we respectfully request a continuance until February so we can get that stuff done and be prepared to try the case.
And Your Honor, if I could add just a couple of things real quick. I'd like to echo everything that Micah and Brett have said. But as far as some of those motions that they're talking about, 3 of them are motions to compel some fact witness depositions, which are all scheduled at various times throughout August. 2 of the motions to compel are August 16th. Then the other one is August 23rd. And then we have the motion for contempt of Billy Nip, who has already been compelled to appear for his deposition in this case, and he has still failed to do that. The hearing for the motion for contempt is also on August 16th. And then finally, we've worked with plaintiff's counsel and tried to reach an agreement on getting some independent medical evaluations done we weren't able to reach an agreement without seeking judicial intervention. So we have that hearing set for August 20th. We have expert reports that are needed to be done, and those same depositions that need to be done with these experts that need to do these evaluations before they can make any substantial progress in those reports and depositions.
I guess why hasn't it happened up to this date? Just because I guess some of the parties were added late? Is that kind of the delay, or?
Various things, Your Honor. Some of the parties being dismissed and haven't been responsive to having their depositions set. For example, though, within the past couple months, we were able to depose two fact witnesses, John Suits and Mr. John Wedeking, who were both first responders on the day of the incident. Well, just to complicate matters more, for example, Mr. Suits' deposition, or Mr. Suits is in another country right now, 13-hour time difference. So working with him and all the attorneys involved to get that deposition scheduled was not an easy task, but we were able to have his deposition taken.
Okay.
And Your Honor, if I may, we've, I guess, approximately 15 or 16 depositions have already been taken in the case. So it's not for the lack of effort of trying to get this case worked up for trial, but because the plaintiff is alleging exposure to a gas leak and permanent injuries, we've had to take many fact witness depositions to help prepare the case for trial. And now we're in a position that we need to finish the fact discovery, mainly with Billy Nip and representatives of the settling operator owner of the well, and then go into expert witness depositions, which necessitates our request for a continuance until February.
And this is a single injury case, like there's only been one person was injured?
Correct. There's only one injured plaintiff. Yes, Mr. Kimmel.
Okay. It's just this has gotten really old. In February is getting to be really crowded. Let's see, you're set on the 28th right now. Let me see. So you still have to take how many more depositions?
Your Honor, as of right now, with what we know now, there's at least, we have our 3 experts that will need to be deposed. Then 2 of plaintiff's experts need to be deposed. So there's 5 in total just between our doctors. Then there's at least 3 fact witnesses from the settling parties that need to be also deposed. And then, of course, Mr. Nip's deposition, if we can get that taken care of.
Let's see. I mean, given the age of the case right now on the 28th, at least right now, you guys would be number 1. And so, I'm just wondering if you couldn't get it ready by then. It doesn't seem like you still have a month and a half before then, and you've been to mediation, right?
I believe the mediation occurred prior to Griffin getting involved in the case, and I'm not sure if RAE was involved at that time of mediation. I'll let Brett speak to that.
No, we have not been involved in a mediation.
And who are you going to mediation with? When is that set? When is mediation set?
Hey, Your Honor, I'm pulling up the file right now to see if there's a current mediation scheduled.
Currently, we don't have a mediation scheduled between the parties.
Who's your mediator? Have you agreed on someone, or did I court appoint somebody, or what's the status?
I don't believe there's been an agreement reached as far as mediation at all yet, Your Honor.
Did you guys mediate with the prior parties already, you said?
No, sir. They had a mediation prior to Griffin and RE being involved in the case.
And who was the mediator then?
I'm not sure off the top of my head, Your Honor. I was looking at the file.
Yes, sir. I'm looking right now, Judge.
Let me see if I can look it up.
I believe it might have been with Randy Aiken, Your Honor.
I believe that's correct.
Who's Randy Aiken? I've never heard of him.
Yes, sir. He is a mediator here in the Longview, Gray County area.
Okay. I mean, is he a good mediator? I don't know anything about him.
Yes, sir. I believe he's a good mediator, and he's one that's had experience with both sides agreeing on in the past, but I don't want to speak for any of the other parties. But I think he's a good mediator.
Let me see. I don't see a.
It looks like there's a letter in the file, Your Honor, from Mr. Aiken addressed to the court indicating that the case was mediated on March 13th, 2020 as to plaintiff and defendants, Griffin Holdco LLC and Ray Systems Inc. and third-party defendant Lasso Technologies. And unfortunately, the case did not settle at mediation.
But I guess it later settled with some parties.
Yes, with S&D and Vortis, I believe.
I guess I see it there. Let's see. What was it, the mediator's fault, or was it the parties, or what was the issue? And I guess why are we using a mediator from out there anyway? I mean, this is Dallas County.
I apologize, Your Honor. I don't know the answer to that. I would just, he might have been proposed and the parties came to an agreement on him.
Did I enter an order substituting in Mr. Aiken?
Let me look.
I'm not saying I wouldn't, but sometimes when I don't know the media, I've never heard of this guy. Mr. Smith, who do you want to mediate with?
I'm fine with the same mediator, Your Honor.
Have you used him before?
I've heard of him. I personally never have.
I mean, would you rather use somebody local like Mark Gilbert or Ken Rubenstein or someone like that, or do you want to use?
Well, the issue with Mark Gilbert is scheduling. Frankly,
Yeah.
so busy. But I often use Mark, and I think he does a good job on behalf of plaintiffs and defendants. So I'm fine with using him.
I mean, or Ken Rubenstein, or there's dozens and dozens of good mediators, Mike McCullough and Karen Gammon, Mary Burton.
Yeah, I think
you know.
Mark Gilbert or Mike McCullough, Gary Berman's fine with me.
Is Berman, I mean, this seems like a pretty big case. Is Berman doing these type of, does he do this kind of stuff, or he always used to just do the smaller cases? Is he doing bigger ones too?
Right. I've had some bigger cases with him.
Did they get settled?
I don't know if he's doing full day mediations.
Yeah.
With this case.
I would assume you'd need a full day mediation on something like this.
Yeah.
And Your Honor, just from my understanding as to the complexity of this case and Mr. Aiken's already familiarity with it, I know that we would be comfortable using him again, but I've also had cases before with Martin Gilbert or Jim Janot at his office, and think highly of.
Jim Janot is a good mediator too.
I agree with that, Your Honor.
Well, I guess, my concern, I guess, is you've got a trial setting here. You're actually number one, even after all the COVID stuff. If we move you to February, the likelihood that you're number one again is, not great. And I need to get cases tried. And so I'm hesitant. I'm not saying I'm not going to do it, but I'm hesitant to move a case of this age. At this point, it doesn't seem like that there's really, if you guys put this on top priority, I think you can get the depositions done. You might not be able to get in with Mark Gilbert, but there's a lot of other good mediators you could. Maybe this guy Aikens, I don't know what his schedule's like. I'm just hesitant to do that. And you guys have all been in this case for well over a year and a half. It's not like somebody was just added. Am I understanding that correctly?
Yeah, as I said, Your Honor, we were added in the latter part of 2019.
Yeah, so that was 2 years ago then.
It was. And there's been, as I said, there's been 15 or more depositions already taken after written discovery's been done. And there's been issues with trying to get additional fact discovery with the settling defendant, which is critical to address the liability issues and damages issues in the case.
Have you brought motions that I've denied, not letting you do that discovery?
No. You have compelled at least one of the witnesses who was employed by a settling defendant to show up for deposition. He did not, and Griffin filed a motion for contempt. That's still.
I see that set soon, right?
Yes. But this case involves pretty specialized equipment regarding sensing releases of gas, as well as notification of authorities as a result of the release. And it's a very expert intensive case. And those depositions have yet to be taken, in large part because we're still trying to collect the facts from all the relevant witnesses.
Would it make sense to do the mediation before the experts are taken? Or sometimes it is a good idea and sometimes it's not.
Yeah, my preference, Your Honor, would be to have the experts do their written reports at a minimum before we mediate the case, so we know what the experts' opinions are, at least on paper, to give us a better idea of what the positions are of the parties.
Aren't the expert reports due by now?
Not as of yet, Your Honor.
What do they do?
As of right now, Jordan, do you know?
Yeah, Brett. So actually, Your Honor, the plaintiff's expert report deadline was in early June, and the defendant's was late last week. But because of all the outstanding issues surrounding depositions and the outstanding discovery, we all agreed to withhold our expert reporting deadlines until after these are resolved.
Until after the depositions issues are resolved?
Yes, sir.
How many depositions still need to be taken? You said 2 or 3?
No, I think
besides the experts, how many fact witnesses?
As fact witnesses at a minimum of 3 right now.
Well, there's going to be more than that.
No.
Because if I may interject, They have asked for a corporate rep deposition of one of my client's reps, Your Honor. And we've been trying to determine, based on the topics provided, who and how many. And as of right now, it seems to be 3 or 4 people from my client that need to be deposed. So to address the issues contained in the topics list that was provided.
Okay.
So to have those depositions done and then have the expert reports done, to have a trial in September, it doesn't look like we can be ready at that point, which is the reason why we proposed this new scheduling order, Your Honor.
I mean, what one other concern that we have right now, just generally, it's not related specifically to this case, is that, you know, we're in the middle of a pandemic. We're all hoping it will end soon, but it doesn't seem like it's happening. And so, you know, my hope is in, you know, a couple of months that maybe things will be better, but I've been hoping that for quite a while. And I thought we were done. I think a lot of us thought we were done. And so one of the things that I'm encouraging people to do, and so far my first 4 jury trials we've had, in-person jury trials, have all been with 6-person juries. What I don't want to see happen, and this is you know, a serious concern, is let's say we move this to February and we're still in, you know, a COVID threat level of orange or yellow, or orange or yellow. If it's red, we wouldn't be doing jury trials. We're trying to get people to agree to a 6-person jury in that situation. Only if we're still in an orange or yellow. If we're to green, then it doesn't matter. But if an orange and a yellow, and so I'd be more willing to move this if the parties could agree that when this case goes to trial, they would agree to a 6-person jury if we're at a COVID threat level of orange or yellow. And I know you guys probably can't agree to that right now, but scheduling right now to get a 12-person jury is extremely difficult. And hopefully by February, we'll be out of this COVID issue, but I'm not 100% sure. I don't think any of us can say that's going to be the case. And so what I would suggest we do is maybe you talk to your clients, tell them, like, look, the judge is hesitant to move this, but if we agree to the 6-person jury, if we're in an orange or yellow threat level, he's willing to move it to February, so that we don't have that as an issue that may move the trial again. I'd be more comfortable moving this. How do you feel about that?
Your Honor, for the most part, I'm fine with 6-person juries. That I would need to talk with the partner, Carson Runge, about that, just so I don't overstep in that regard.
Mr. Smith?
Yeah, I just have to talk to my client, Your Honor, before I provide a response.
Okay. Mr. Caruso?
Same, Your Honor. I don't think it'd be a problem, but I'd like to talk to my client and my partner also to get confirmation of that.
So we have another hearing set, what, next week on this?
Yes, sir. August 16th.
Or 2 weeks from now. So why don't we do this? Let's punt this to the 16th. If you guys could talk about one, and again, it's only if we're in threat level yellow or orange. If it's red, we won't be having jury trials. If green, I don't care. I don't mind doing it. Obviously, I've done, as Mr. Smith knows, I've done hundreds and hundreds of 12-person jury trials. It's just during this current threat level, it's very difficult to do those, especially with the new rotation system we have, which hopefully will be temporary. So the only risk here is that in February, if we're in yellow or orange, you'd have to agree to a 6-person jury. I'm not going to require it if it's green, and we won't have trials at all if it's red. So does that make sense? If you can't agree to that, then we need to talk some more. I'm not saying I won't move it at all, but that means I'll probably put you on it for all the cases that are on a 12-person jury, or insisting on 12-person juries when we're in yellow and orange. I'm putting you on a rotation where you kind of, so basically you'll be on standby for a number of days or weeks until we can get you a 12-person jury, because we can only do those jury selections in the central jury room, and then we go on a rotation with the other judges. Does that make sense?
Yes, Your Honor.
Yes, Your Honor.
Mr. Smith?
Yes.
Okay. All right. So we'll see you guys back in a couple of weeks. And at that point, if you guys can just try to agree on a mediator, and then we can talk about the 6-person jury issue. Okay.
Very well. Thank you, Judge.
Thank you, Judge.
All right, guys. Thank you. All right. I think we have a motion for continuance set. Are you guys here for the motion for continuance?
Lauren DiGirolamo here for the defendant.
I just unmuted. Warren Hayes for the plaintiff, Your Honor.
Okay, great. So you guys, this is the first time I've had this complaint. I've been getting the opposite complaint. I usually have been doing hearings on all of my agreed continuances just to talk people through this whole COVID issue. And I guess I didn't in this case, and you guys were hoping I had, so I apologize about that. Let's kind of talk through what you want to do in terms of the trial setting, and I'll kind of explain to you what's going on with COVID. So tell me what's going on, guys.
Your Honor, this case is, that's the third sitting. What happened was, I think, the court just reset the last agreed motion, and I didn't get a chance to give input. No, that's the one time I can't do it. About that time, I'd set a vacation with my wife, which she's still talking about. And I haven't told her there's a conflict yet. I haven't told her there's a conflict yet. I hope we can get this resolved. And that's basically where it is. Just with the court's indulgence, if you want to set us a month later, 2 months later, I think that's fine. I've got the defense doctor's depot at the end of this month. And I just talked to Lauren today for the first time, and she's asked me that we might entertain settlement. So maybe even before the doctor's deposition, we'll make another run at trying to settle the case. But I can't have this hearing. I'm sorry, Your Honor. I've 44 years, I'm sorry, being married. And,
Congratulations. That's awesome.
Thank you.
Well, I'm happy to move it at least a couple. How long is your vacation?
I mean, we're poor folks. It's only that week. It's only like 3 days.
Do you want me to move? I can move it a couple weeks. If you want any more than a couple weeks, then I would have to really talk about this 12-person versus 6-person jury issue.
I was hearing you talk about that. Lauren, you're the one that's the new hire. What do you think? What would you prefer? I'm at the court's pleasure, whatever you want to do. I'm just asking to get out of this trap.
And let me tell you what the issue is. I'm so sorry, I didn't mean to interrupt you, but let me kind of tell you what the issue is. And that is, obviously we're in the middle of a pandemic. We have a new rotation system for the judges, and I can go into all the details with it, but essentially we're able to summon one 40-person jury a day, or a week, per jury day. We can summon 2 or 3 6-person jury panels, or so 20-person panels versus 40-person panels. I'm very uncomfortable doing 12-person juries in my courtroom because of social distancing and the Delta variant. And so I require you to wear masks throughout the entire trial if you're going to do 12-person. And so I don't want to be in a situation where I'm moving your trial, and I will move it no matter what, even if the opposing counsel says that she won't agree to a 6-person jury. But I'm not going to move it a lot, because what will happen if you insist on a 12-person jury is we put you on a rotation. Sure. and you'll be on standby for, until we can get a 12-person jury. And anyway, I don't know what your thoughts are on that.
Your Honor,
it's my instructions from my instructions from my firm that I'm not to agree to a 6-person panel.
Your Honor, I would agree to it, but I heard what Lauren just said, so.
I'm sorry, my dog was barking. I apologize. What did you say?
No worries. It's my understanding from my firm that I'm not to agree to a 6-person panel.
Okay.
It's fine with me.
All right, so we'll move this then just 2 weeks, and we'll put you on the rotation. And so you might want to tell them just that obviously the court feels that, assuming, and all we're asking for is, as long as we're in yellow or orange, that you agree to a 6-person jury. If you do that, and assuming the pandemic doesn't get worse, but then we go to red, we wouldn't have jury trials anyway. You'd be able to not have to wear a mask during certain parts of the trial. If it's a 12-person jury, you have to wear a mask the entire time. You go on a rotation, which means you'll be on standby for potentially up to 3 weeks, so that's unlikely. If you do a 6-person jury, you get to pick the day you go to trial. And I understand you may need to talk to the other attorneys at your firm, but a lot of the defense counsel are now agreeing to this, given kind of seeing the situation. But we can cross that bridge as we get closer to it. We'll set your trial's currently on September 28th. Why don't we go ahead and set you to October 12th? How does that sound?
That's fine with me, Your Honor. Thank you.
That's fine, Your Honor.
All right, Rhonda, go ahead and reset them to October 12th.
We'll exchange letters